speaking, but we couldn't hear him because he was on mute.
Okay.
Yeah. Sir, go ahead.
Mr. Chair, this is Paul Houston Lavalle, the respondent herein.
This is a compulsory discipline hearing under Rule 804 of the Texas Rules of Disciplinary Procedure. When an attorney has been convicted of an intentional crime or placed on probation for an intentional crime, he shall be suspended as an attorney licensed to practice law in Texas during the appeal of that conviction. Earlier today, we rendered or issued a written order regarding respondents' objection to remote proceedings, as well as an order denying a plea in abatement. I have before me both a notice of removal that was filed on May 12th, 2020 by Mr. Lavalle, and a response to the notice of removal filed today. Mr. Berry, the board had reviewed your filing and appreciate the clarity and the guidance related to the notice of removal. And so at this point, Mr. Lavalle, I would ask, I'm actually going to turn it over to you. There's 4 different arguments that were made in response to the notice of removal. And I'd like to begin with your arguments in response to, first, the matter of subject matter jurisdiction. The petitioner is arguing that the federal court does not have subject matter jurisdiction to hear state disciplinary cases. What is your position on that matter?
Sir, regarding the removal, I choose to stand on the pleadings on file.
Okay. And so would you like me to inquire as to the responses to the other 3 arguments made in the response to your notice of removal, or just assume that you will have the same answer for all of those other 3 subjects?
The answer would be the same for all 4, Mr. Chair.
Okay. Mr. Berry, do you have any response? Anything you else want to say regarding your response to the notice of removal?
Well, I would stand on my pleading. If you would like a summation of the arguments, I can give those to you very briefly for the record.
You may.
Okay. First of all, this is an administrative proceeding. It is not in a court of law, so I could find no authority that would allow an administrative action to be transferred or removed to federal court. That's number 1. And I'll do these briefly. Number 2, although he calls it a notice of removal, the pleading he actually filed is not a removal of the suit against him, but a separate cause of action against Shauna Willing, who's chief disciplinary counsel. It's a totally different case. And he also requested a stay or injunction or temporary restraining order, but there is no, the court has not issued an order on that request. Number 3, it's procedurally defective. He had 30 days under the federal rules to file a removal, even if he could, even if it was a removal, which we don't concede that it is. He didn't do that within the time limit, so it's facially defective because he waited 57 days to file what he calls a removal that's actually a new suit. 4th is the jurisdictional issue. And I think the case of Musselwhite versus the State Bar of Texas clearly sets out, and that's a 5th Circuit case, that the federal courts don't have jurisdiction to hear disciplinary matters. That's our arguments in a nutshell. And so I would respectfully request that this board find that retain jurisdiction over this case and proceed with the hearing today. Thank you.
Mr. Lavalle, any response?
Respondent objects generally.
May I inquire if there's anything with particular concern about the due process proceedings that are either raised in your federal suit or in your objections here?
Mr. Chair, I believe all of my pleadings speak for themselves.
Okay. So nothing further that you wish to address regarding the notice of removal, sir?
Not in this forum, sir.
Okay. Anything else, Mr. Berry?
No, I would just say that I think the due process requirements are met. There are procedures that were written that were given with the notice of this hearing, and all that's required for due process is notice and an opportunity to be heard. And I think Mr. Lavalle has been given those due process requirements.
Thank you very much. Council, because we're a panel, what I'd like to do at this time is go off the record so I can confer with Ms. Stone and Ms. Tisdale related to the matter. We'll be in recess. Ms. Truitt, if you can please place the parties in the waiting room. We'll